A home is often a family's biggest investment, so people are often wary of changes in law or circumstances that they fear may compromise their home's values. Such arguments were often raised in opposition to measures that opened housing to African Americans and other racial minorities, and the continued viability of single-family zoning was raised in City of Edmonds versus Oxford House. The Federal Fair Housing Act, which we'll call the Act, prohibits housing discrimination against persons with handicaps. Section 3607B1 of the Act exempts and allows any reasonable state or federal restriction setting the maximum number of occupants in a residential dwelling. The City of Edmonds in Washington State enacted an ordinance governing single-family dwellings. The city's ordinance allowed a family, defined as any number of people related by genetics, adoption, or marriage, to live in a single-family home. But no more than 5 unrelated persons could live in a single-family home. Oxford House opened a group home designed for 10 to 12 adults recovering from alcohol and drug addiction. The group home was located in a neighborhood zoned for single-family dwellings. The city began issuing citations to Oxford House for violating the occupancy ordinance. Oxford House asked the city to allow the group home to remain within the single-family neighborhood. The city declined. The city sued Oxford House in federal court, seeking a declaratory judgment that its ordinance came within the Act's exemption, and Oxford House countersued. The parties stipulated that recovering alcohol and drug addicts constituted handicapped persons as defined by the Act. The district court held that the ordinance came within the Act's exemption and ruled for the city. The Ninth Circuit reversed. The United States Supreme Court granted cert to resolve a circuit split.